Hi, y'all. Rob here from ATX Legal. First off, just the disclaimers. This is not legal advice. We're not talking about your specific situation. If you do want legal advice, you're always free to call or visit ATX Legal and schedule a consultation. It's completely free. I'd be glad to talk to you about your case. But today we're going to be talking about assault family violence, specifically about what to do if you're charged with assault family violence. So obviously this is a very difficult topic for some. I'm not really going to get too far into the politics of it. I do want to just bring up a couple quick points about family violence that makes it that just adds a level of complexity for trying these cases and for handling these cases in court. They're going to be the most difficult cases for prosecutors to try, and they're also going to be the cases in which more people are falsely accused than any other cases. Why? Well, most of the time, these family violence charges happen between two people. There are no witnesses. So the prosecutors and the police have to establish what happened by circumstantial evidence. And that means that there are people who commit crimes that go free, and there are also people who don't commit crimes that are falsely accused, and those false accusations can carry a lot of weight. And those can be the worst cases because you have innocent people in custody, awaiting trial, and can make these cases very difficult. So it's no surprise that most people watching this video will know that in recent years there's been a bit of a crackdown on domestic violence. And the reasons for that are pretty simple. It's been in the shadows for many, many years. It was the look the other way kind of charge. So that is changing, and in a lot of ways that's a really good thing. In some other cases, you have people falsely accused. It's a really bad thing. But that's why it's really important, specifically in these cases, to hire a good defense attorney that is going to be paying attention to your case and really holding the prosecutors to the flames and making sure that they can actually prove their case before you settle on a quick guilty plea. So I'm going to start with jail release. Jail release in family violence cases is not like a typical DWI. It's going to be a little bit more difficult. One of the main reasons why is the judges are in no hurry to get people out, so that a lot of times there are repeat offenders. They don't want it on their hands if they let someone out who goes out and commits family violence again, or God forbid murders someone. So the judges are not going to automatically release people like they often do with DWIs. A lot of times you're going to need to hire an attorney even before you're released from jail. And when you are released, there's often conditions involved. About 95% of these cases, there's going to be a stay-away order as part of the conditions of the bonds. And now that's separate from a protective order, and we'll get to that later. But as a condition of the bond, the judge is going to say you can't have contact with the alleged victim. And for some people, that's not a problem. For other people, if they're living with that person, well, now you're going to have to find another place to stay. So that's often a complicating factor, and you have to have that new place to stay before you're released from jail. So if you can't secure that, it's going to be a problem. Other times there is an ankle monitor. That's obviously not fun, but if you do comply with the ankle monitor, usually after 45 to 90 days, you can get that removed. Now the protective order, which I was talking about, that stay-away order with the bonds, the protective order is a separate matter. The alleged victim would have to petition for that. She would quickly on pronouns, I will be usually referring to alleged victims as she, alleged defendants as he. That's not the case for every case, but it is just the percentages work that way. So with a protective order, if she wants to get a protective order in addition to the stay-away order as part of the bond, she will need to petition the court. It's a separate issue, and she'll actually need to go testify as to the reasons why a protective order is needed. Now she'll have to, or the prosecutor or whatever attorney is getting the protective order, because it can actually be the county attorney or a private attorney, They will have to show that family violence has occurred and is likely to occur in the future. Now, if they can't show that, and they have to show both of those things, then they can't get the protective order. Now, it can be pretty easy to show these things, but it's always good to go to those hearings to question the person requesting the protective order, because if there are cracks in the story, they will often come out in the testimony because they'll be under oath. They'll need to be truthful. I've had one case where a client was charged with some serious felonies. We went to the protective order hearing. I was able to question the witness whose story just did not hold up at all, and was able to get 2 serious felonies dismissed completely, basically on the testimony that was given at the protective order hearing. So they can be very important, not just for the stay-away order, even if that stay-away order is going to be slapped on regardless. Getting that testimony under oath can help immensely with the other cases. So what is assault family violence? It's actually really simple. It's just assault plus it's against a family member. So assault can be a lot of different things. Even the threat of bodily injury, even if you don't actually cause bodily injury or even touch someone at all. Even unwanted physical contact, like a tap on the shoulder, if that contact is clearly not wanted, can be assault. So it incorporates actually a wide range of behaviors, and the conduct must be done intentionally, knowingly, or even recklessly. So for an example of recklessly, I had a client that slammed the door. He was in an argument and had no intention of harming, but the door fell off its hinges and struck the alleged victim. He didn't mean for the door to come off its hinges. He just slammed it really hard, but that's considered reckless conduct, and he was charged with assault. Now, in addition to assault, for it to be a family violence charge, it has to be against a spouse, a family member, a dating partner, in some cases even a roommate, and that can be litigated. But there is, if you're in a relationship with someone or someone is your family member, that can be charged as assault family violence. And that's called an enhancement, and it creates a lot of different things, which we'll talk about later, but it just makes the charge more serious. First time family violence is a Class A misdemeanor, which is punishable with up to a year in jail. It can be bumped up to a felony if it is charged as assault impeding breath. So it also is called strangulation. So strangulation is up to a 3rd degree felony, and that's an offense that is committed by intentionally, knowingly, or recklessly impeding the normal breathing or circulation of blood by a person applying pressure to the throat or neck or blocking the nose or mouth. So it's obviously more serious when someone is being choked. That's obviously a more serious charge, but a lot of times this is getting charged without any evidence. So people who have been, unfortunately, alleged victims tend to have this happen over and over again. When that does happen, sometimes they want to get someone arrested, and they want them to get arrested on more serious charges. So they'll say, oh, he was choking my throat. They know to say these things. So even without evidence, sometimes police will up the charge to a 3rd degree felony on a word. So you can see how that can be problematic when you have 2 people who, at the moment, they don't like each other, and one person knows exactly what to say to get the charge up from a misdemeanor, which is already serious, to a felony, which is far more serious and is going to lead to very serious consequences even before anything is proven. So if you kind of are reading between the lines here, you're seeing how this can be a very, very problematic thing, both for prosecutors and defense attorneys, because these motivations can go both ways. In a sense, a person could be falsely accusing someone, or it could be a completely legitimate charge, but there's really no way to tell which it is. But in these situations, American jurisprudence has decided we side with the defendant. We are not putting someone in jail unless it is proven beyond a reasonable doubt. And that's why having a good attorney on this to point out that reasonable doubt when it's one person's word against another is so important. Okay, so now we need to talk about the family violence finding. And the family violence finding can be on a misdemeanor or a felony. And it is a special enhancement in addition to whatever penalties you have from the conviction. So with family violence misdemeanors especially, the main focus is on keeping the charge from having a family violence finding. Why? Well, first of all, just as a threshold, if you are given a conviction with a family violence finding and you get convicted a second time, or if you get charged a second time, that second charge is automatically bumped up to a felony. So already that's reason enough. But in addition to that, there's a bunch of other things that go along with that. You can never own a gun the rest of your life. You can be deported if you're not a U.S. citizen. You can never adopt or foster a child. It can have a huge effect on child custody proceedings if those are part of the case. Your hunting and fishing licenses can be denied. I don't know how family violence relates to fishing. It just seems like an excessive punishment, but it is what it is. And your case cannot be sealed, so it will be on your criminal history till the end of time. So we know it's bad. So how do we get around a family violence conviction? So really the only good way to do it is to get your case dismissed. Because if you a plea deal that results in a conviction, there's automatically a family violence finding. The judge, the prosecutor has no way to take that off. Even if you do a deferred adjudication, which is not even a conviction, that still results in a family violence finding that cannot be taken off. You can specifically say and have the judge put on record, there is no family violence finding in this case. And if a later prosecutor decides to prove up a family violence finding, they can do it by going into the actual the proceedings of what happened and pulling out details that could lead a jury to say that's a family violence finding. So really what you want to do is get the case dismissed. Some even attorneys think that if you get the deferred adjudication because it's not a conviction, there's no family violence finding. That's false. So make sure you sit down with your attorney and fully understand what the ramifications are if you are deciding to do a plea deal that involves a conviction. So how do we fight family violence cases? So obviously each case is going to be different, but there are patterns that show up again and again in these cases. Usually the evidence is going to be either statements only or statements plus physical evidence. Obviously cases where there's physical evidence, bruises, scrapes, those are more difficult cases, but there's still a lot of leeway as far as how those bruises arrived, like what caused that. There can be a lot of back and forth there. Are the statements credible? So oftentimes you have an alleged victim who, like I said before, unfortunately, this has happened to again and again. Sometimes they're on their third or fourth assault family violence case while the alleged defendant is, when the defendant is experiencing this for the first time. So we look at patterns in the behavior of the alleged victim, but also in the defendant. If he has never been charged, has a clean history, that's very important. Are there pictures of injuries? Obviously, that's going to make things much more difficult. What's the emotional state of the alleged victim immediately after the incident? A lot of times there's an interview that's on body cam. You can see how this person is reacting. Does the alleged victim want to testify? And that's a difficult issue because we can get an affidavit of non-prosecution, and these days prosecutors are kind of looking at that and throwing it aside. They can subpoena the alleged victim to come testify even if she doesn't want to. So just because we have an alleged victim that is not wanting to press charges does not automatically make the case go away, but it does strengthen the case and it does increase the chance that we're going to be able to come to a resolution that involves some kind of dismissal. As far as outcomes, obviously, like we just talked about, dismissal is best, but there's a couple different ways we can get there. there's something called deferred prosecution. And this is a good compromise. If this is ever on the table, I usually urge my clients to consider it. It involves a dismissal right up front. Then you have to complete certain requirements. What is that? That's anger management classes, community service, maybe pay a fine, sometimes have a continuing stay away order from the alleged victim, and obviously pick up no new charges. That's always one of the conditions. And once you complete those requirements, you can typically have the case expunged from your record. It looks exactly like a dismissal on your criminal history, and in fact, it is a dismissal. There's no family violence finding, so that's not a concern. So in cases where the prosecutor strongly thinks that something did take place, but maybe there's weak evidence or not enough physical evidence, a deferred prosecution is a great compromise. We get what we want, and the prosecutor can at least make the claim that they're protecting the community, which they are, because all these conditions are still in place. So deferred adjudication is like a probation, but there's no conviction. But like we talked about, the family violence finding does attach. I don't typically think the deferred adjudication is a great option for family violence cases. If you do violate your deferred adjudication, the judge can assign a penalty. That's not pre-negotiated, so the judge could give jail time if there's a violation. Probation is the next level, and that does involve a conviction. Family violence finding, this is kind of the last resort. If there's overwhelming evidence that something did take place, then probation can be an option. And then, of course, going to trial. Trial can actually be an attractive option for family violence cases because of what we talked about earlier, where it's often he said versus she said. There's really no proof that anything happened. So forcing the issue to trial can do a couple things. One, if you do go to trial, it puts it in the hands of a jury, not a prosecutor who handles family violence cases day in, day out and has gotten jaded. But also it can force the prosecutor to actually examine their case, and once they do that, they might see the holes themselves and offer you a better offer than they had been offering before. So more often than other cases, I am putting family violence cases on the trial docket. Now, whether those actually go to trial or not is a different thing, but forcing the prosecutor to get to that point gets you a lot of good outcomes. All right, now let's talk about penalties. So for a Class A misdemeanor, it's a fine plus up to 1 year in jail. For a third-degree felony, which would be a strangulation, or if you're charged with a second family violence and you get convicted, that's 2 to 10 years. So obviously, very serious consequences here. However, there is a high success rate. It's one of the lowest conviction rates in the prosecutor's office for a reason, for all the reasons we talked about. So that's why the combination of extremely serious consequences plus a high degree of success, if you do fight the charges, is the reason why you really need a good, strong attorney looking after your interests in a case like this. So we offer case evaluations. If you're on the fence, you just watch this and you have charges and you would like to talk about your case, free case evaluation, just go to atx.legal. You can schedule that with a form there, or you can give us a call. Glad to talk to you. Other than that, good luck with your case.